Zay, and we're live. Yes, good evening, folks. A lot of very interesting things that happened today in the legal world of South Africa, specifically pertaining to the issue of harassment orders. Now, let me give you a little bit of background to what the harassment order is. Originally, we sat with a piece of legislation in South Africa relating to domestic violence, in terms of which a party that was the victim of domestic violence could approach court and get an interdict, a very easy and cost-effective and time-effective, a very efficient system to obtain an harassment order against the person against whom the allegation was made that harassment is taking place in the domestic environment. In other words, husband, wife, children, parents, grandparents, domestic, in other words, domestic in its nature. So very soon after that it became clear, and that was also in line with legislation from foreign countries, that we needed an extension to that, and that being harassment or stalking of private individuals by other people that are not related to them. So I'm not going to deal with domestic violence tonight, but the same principles, or very close to the same principles, is applicable to both sets of law and legislation. Harassment orders in South Africa is governed by specific legislation and rules of court. The so-called, in layman's terms, Harassment Act. In other words, it's an act of parliament, it's a wet van die parlement, and as such, everything and anything relating to that must be done in terms of that law, that act. Otherwise, it becomes what is called ultra vires, in other words, outside the bounds of the law. And if something is ultra vires, then by its very nature, it's illegal or unenforceable, and therefore it's null and void. Okay. In short, here is the very simple procedure relating to harassment of a person. If a person feels that another person harasses him or her, what is harassment? The Act provides for a whole list of criteria of what harassment is. We're not dealing here of civil law. We're not dealing here with a situation where you can remedy the situation by simple summons. It's a little bit different, but usually you have a criminal as well as a civil side to this also. But where a person feels that he is being harassed by another person, that person can go one of two avenues. That person can report to a police station and open a docket in terms of the Harassment Act, and then he is usually sent by the police, by SAPS, to court on a specific day to obtain what is called an harassment order. I will get back to that in a moment. The other way around is where a person approaches the court directly, which a person may do, where they can simply go to the clerks of court of the harassment division. It's usually at the courts a domestic violence and harassment division, and where they then put the case on the roll there, and then by filling out certain pro forma documents. Okay. Now that ends up in an application before the court only by the applying party, the applicant. So the applicant is the person who appears at the first session of that court, whether that comes from the police or whether that comes from his own referral to the harassment court. The harassment court will then hear his case. If there is merit to his case, to his application, remember this is an application procedure, an interim order will then be granted. Now remember, an interim court order is a court order. Sometimes, especially in law enforcement, we find that people think and people believe that an interim order is somehow not a proper court order. It's not. It is indeed a proper court order. It's just an interim order until such time as a next event take place. Some jurisdictions will then also hand a warrant of arrest to the applicant. Excuse me, I want to come back to that. And some jurisdictions will not hand the arrest warrant as yet. I've seen that in the Free State, excuse me, there's for instance an habit by courts of handing out the arrest warrant there and then with the court order, with the interim order. However, here up in Gauteng, I've found and I've experienced that you must apply separately. Now, okay, let's get back to what happens then. After a party, the applicant obtained that harassment order, the harassment order must then be delivered to the other party. For the very simple reason, if that party, the opposing party, let's call him the respondent from here on, is not aware of the court order against him, obviously it would be impossible for him then to stand before court and answer on that order. It speaks for itself. It's simple law. This is also not in terms of the harassment order or the harassment act itself. It's based on our common law. It's based on the very old adage of audi alteram partem. In other words, both sides should be heard. But it speaks also for itself that if a person is not even aware of a court order against him, that order cannot be enforced against him. Now, how do you deliver that interim order? You can go several routes. Sometimes it will happen that the applicant himself or herself will go and deliver this to the respondent. This is not the usual trend of things, because you came to court in the first place to say that you are scared or you are being harassed by the other person, but it's not unusual or illegal for the party themselves to deliver the document to the opposing party, to the respondent. The respondent, of course, must either then sign the receipt, or if there's witnesses present, those witnesses can put down affidavits later to say we saw that it was delivered. Or if you have footage, video footage or camera footage, photographic footage, then that will also suffice to show that it was delivered. The second option, which is a little more costly, but to my mind maybe the best option, is to instruct the sheriff of court to then go and deliver, and he delivers it and he brings back a notice to court to say, a notice of delivery to say, yes, it was indeed delivered to the respondent on a certain date and a certain time. He accepted the document, it is in his possession. The third, and that is the most usual, is that a police officer is instructed by the court, usually his name or her name, it's usually the station commander of a certain police station, is ordered to then send or deliver this document to the respondent. And usually an officer, not for instance a constable or a learner constable, aspirant constable, an officer would then go and deliver this document to the respondent. Then the respondent has been served in layman's terms. In other words, he has received the interim order on which he then has a certain time period to respond. In other words, audi alteram partem, both sides must be heard. He will then be afforded a time to prepare himself, and the date on which we call it a return date, that case must then again be before the harassment court. This is done all by paper. It's very highly unusual, in fact, for viva voce, in other words, verbal testimony to be led during these proceedings. It's usually done only on paper through affidavits. And these affidavits, of course, from the respondent must be delivered, the responding, the replying affidavits and the case to the original applicant, and that is done in exactly the same way as previously. These days, there's a habit amongst practitioners, if an attorney's firm is present, that is usually done by very simple sending of documents via email. It has become, I think, a very good, but a very common practice between practitioners to send via email, because you have instant proof that the document was sent and received by the other side. Goed. Next process. The next process would be where the other party, the respondent and the applicant, would then turn up at court. The respondent also have the option of shortening the period by application. He may indicate to the court as well as the other party that he doesn't want to only appear after the certain time on a certain date. He can even precipitate that. He can bring the case very much sooner. But the fact of the matter remains that both parties then appear before court for the trial phase of this process. Now, the trial phase is where the court then, the two parties before the court, go through all the documents, all the exhibits. Sometimes evidence is indeed led or presented under oath before the court, and then the court comes to a determination, a finding, a judgment, to find that yes, we will now make this interim order a final order, or we will not make it a final order and we will scrap it from the court roll. When the case is made final, then the final order is a binding one, usually for a very long period of time, and it is a very serious court order that has been handed down. Why is it so serious? Because the Harassment Act stems from one person feeling harassed, scared, humiliated, whatever the case may be, by the other party. And as such, that party then, the applicant party, approaches court. He goes through legal avenues to protect him. He goes to the court, and the court becomes the protector of that applicant. And this is why harassment orders should not be seen as willy-nilly or very light court orders. And the effect of this court order is that the person can go to prison if it is not adhered to. It's as simple as that. Once again, in certain jurisdictions, you will find that there and then, after the harassment order has been made final, a warrant of arrest is issued and given into the possession of the applicant party. Some jurisdictions hold that on the court file, and only on proof that there was indeed a case opened at police would it then be handed to the applicant. Okay, so that is the process. So now applicant party is sitting with a final harassment order through the whole system that has gone past now, and the protection of the court is now over this party. Let's say the respondent then transgresses, contravenes the court order. What happens then? Then the applicant goes to the nearest police station and they open a docket. The docket is called a contravention of court order / harassment order, and it is opened in the usual way by the police officer, who then sent that also to a prosecutor, and the prosecutor then instructs certain things that must be present on that docket, amongst others, and this is the most important thing, and I'm going to get back to that in a moment. There must be proof of service. Remember what I said at the start of this video? Proper service of a document in all court cases must be present for a court to start with a proceedings or issue a certain order against anybody. Okay. If the prosecutor is satisfied that everything has been adhered to, then the case is usually then sent to the harassment court, and then the court will then deal with it as contravention of a court order. Relating to the warrant of arrest, as I said, in certain instances, you will find that there and then, even at the court appearance of the parties, an order of arrest, a warrant of arrest is issued, and sometimes in other jurisdictions you would find, as I explained now, first a docket, first a complaint, then you go to the court, and a court of clerk through the magistrate, and magistrate signs it off, hands you the warrant of arrest. For instance, in Pretoria, that is what happens. The warrant of arrest is not issued there and then. You must show proper cause why it must be taken from the court file, given into your possession, so that it can be executed. Okay, now the next step. now you're sitting with the warrant of arrest because you allege that the respondent, the perpetrator, has contravened the court order. You then go to the police, and the police are supposed then to enforce this arrest order. They must go to the respondent, and if the order is a very simple one of arrest, they must then arrest that perpetrator. Excuse me. Okay. However, the Act make provision that the softest means be used, and that is also in line with the Criminal Procedures Act. The softest means must be utilized to bring the perpetrator before court. If it is deemed to be unnecessary to arrest a person, then usually the police will not arrest the person. However, in most instances, people will be arrested. If they are not arrested, they are handed a J form, a Department of Justice form, on which they are informed of the next court date, and they are warned to appear before court, and then they can go to court to go and fight this case against them of contravention of a court order. If they are arrested, of course, they will then be held in custody until such time, usually 48 hours after that. Habeas corpus, you call it habeas corpus rule. The accused person, he then becomes an accused person, comes before court to apply for bail. Okay, that is in basic terms the harassment orders and the Harassment Act and how the procedure or the process runs. Okay, 2 case studies today. 2 case studies. The first one, in the case of X, I'm not going to divulge the person's name. My wife was indeed the complainant in that matter, the applicant. We went through the whole and exact legal process as of October last year. We obtained an interim order. The interim order was served by a police officer on Mr. X. Mr. X then contravened. We opened a police docket. That docket was properly investigated, sent to the prosecutors, and the prosecutors indicated that it must be acted upon and it must be executed. We returned to court and we obtained the necessary warrant of arrest, and that was issued then and sent to the police station. I'm not going to mention the police station, but to the investigating officer on the file of contravention of court order. Then, through months and months of litigation, hence and forth, the case finally ended up before court again, then for the return date of this and for trial, and on that date the final order was issued by the court, taking into account all the documents that was in front of her, and she decided upon that there is indeed sufficient grounds to then make this interim order a final order. There was a contravention of the final order very shortly after that. My wife returned to court where she obtained a warrant of arrest, in this instance under the hand of the Chief Magistrate of Pretoria North. It was handed to the police, a docket was opened, and subsequently suspect X was indeed arrested. He spent, as far as I could establish, a whole weekend in prison, and he was then brought on that Monday to court where he applied for bail. For some strange reason, the state did not oppose bail. I'm not going to go into the merits. It's not needed for this video. I speak of that on another video earlier on today. And he was indeed then released on bail. Right. Today, his case, the 10th, his case came before court again. And due to certain circumstances, obviously the case could not be finalized. It's not a trial. The case was not up for trial. I will get to that in a moment. And the case was remanded with him under bail, with bail, until the 1st of September. So the case was not struck or removed from the roll for any reason. That is scenario 1 that happened today pertaining to harassment orders. Scenario 2, the very well-known incident of Bolhuis and du Plessis, Izak du Plessis. Here's the short background to that, as far as I can establish it. Izak van der Westhuizen, being a freelance journalist, published certain video material in which Mr. Bolhuis then claims he was slandered. It was not the truth. Mr. Bolhuis then obtained a final harassment order, once again, as I could establish, going through the whole process against Mr. du Plessis. Mr. du Plessis was then warned through attorney's letters by Mr. Bolhuis to take the videos down from his YouTube channel, and it seems to me then that Mr. du Plessis did not comply with that. And yeah, everybody is aware that Mr. du Plessis was then arrested in Nelspruit on warrant of arrest by the police on the request or instruction from the complaining party, that being Mr. Bolhuis. That case also came to court today. Unfortunately for the applicant party, Mr. Bolhuis, that case was removed from the roll by the National Prosecuting Authority because they could not establish whether there was ever proper service of the documents on Mr. du Plessis. Now remember, process and merit, process and substance. So in this case, what happened was that the arrest warrant was issued, and when the case came before the court said we cannot see, we cannot find that there was proper service of this document on the respondent party, Mr. du Plessis, and therefore we are not going to proceed with the prosecution in this instance. Not this case, in this instance, because there is not sufficient case or sufficient evidence before us that is called prima facie evidence. In other words, at first glance, a case that we can bring before court, and the NPA then withdrew the matter before court. Okay, the main final order, as I can ascertain, is still standing. In other words, it's still there. It is just in this particular incident, it seems to me they delivered documents to an old address of Mr. du Plessis. Later on it was sent via WhatsApp. It is not one of the accepted means of delivery of documents, and therefore the court very simply found that there was not, the NPA, there was not sufficient grounds as a prima facie case that could be brought before court. That is why that case was taken off the roll of the court, and tonight Mr. du Plessis is a free man in terms of that specific incident. He's back at home. I see he's making videos already about it. So here's the difference between the two. And I'm not criticizing, I'm not saying the one did the thing right, the other one did the thing wrong. I'm just simply comparing two scenarios so that the public out there can understand why things happen, so that it doesn't appear that we have different sets of rules for different sets of people. Okay, in our matter against Mr. X, everything was done exactly in terms of law, exactly, to the letter, and therefore there's a very strong case, to our opinion, now before court. In fact, certain further charges are going to be added to the case, not the docket, the case. Remember, the NPA may add charges against an accused person until the point of plea. If the plea already took place, you can't put new charges on that charge sheet. In a new charge sheet, in a new case will have to be opened. But until such time as pleadings, the state may add all the cases and all the charges that they feel deemed to be heard before court. This is just simply to ensure effectiveness of the judicial system and stop us from having a lot of different cases of the same person in a lot of different fora to be decided one by one. Okay, it saves time, costs, and it's the efficient way of doing proper litigation, the proper administration of justice. Okay, so that was our case. In the case of Bolhuis du Plessis, it's very clear that the specific 100% black letter law, rules and regulations apparently did not apply, were not adhered to, and therefore the NPA decided that they will not proceed with a case against Mr. du Plessis on on the set of facts that was presented to them. I think it was somewhere during last week. It is the prerogative of the National Prosecuting Authority to either proceed with the case or not to proceed with the case. Okay. The court itself could also do an investigation and find that there was, for instance, not proper service on a person in a case, and then he is found not guilty of contravention of a court order. That's something a little bit different, but it's in the same vein of what was happening here. Okay, so to sum up, people sometimes become confused by the administration of justice. They say there's different rules or different sets of rules for different people. No, the law is the same for everybody. The crux lies in how do you apply the law. There's always, in all law, you will find a process or procedure, and you will find a substance or a method. What's the difference between the two? The process is the process that is set down there so that fair administration of justice takes place. It means that all parties must be informed of their cases, all parties must be in a position to present their cases, prepare for their cases, and then have a fair hearing in their cases. That is the process or the procedure. That stands apart from the merits or the substance, which are simply the facts of the case. So you could have the full procedure, but then on the merits of the case, a person then wins or loses. When you go back to the procedures, you will sometimes hear on the technicalities of law, on a technical issue, a case was removed from the roll. That simply means that the whole process as prescribed by law was not followed. So it doesn't mean that there is no merit in the case. And that is the distinction between these two things. I want people to understand this so that they don't become confused and misled as to what is going on and what is not going on. Okay, if you found my video to be very entertaining or informative or educational for yourself, this is going on to my YouTube channel. And please then subscribe to my channel and click follow and click subscribe and click the button to show that you can receive notifications in future for similar videos. I thank you so much for your time. It was my honor to present this piece of information to you, and then I will see the comments, and if need be, I will address that in a follow-up video. Signing off, Skalk van der Merwe.